I make a brief record and motion regarding some of the testimony that, or videotape that the jury watched yesterday?
Yeah.
Your Honor, I would like to start out by saying that we maintain and in no way waive any of the objections or arguments that we've made in our previous motions D201, D221, D248, D249, and D264A with respect to the statements of Mr. Holmes on these videotapes as a whole, and also with respect to all of the specific statements identified in motion D264A. And having said that, at this time, the defense moves for a mistrial. The basis for this motion for a mistrial is that yesterday, as the court knows, shortly before we recessed for the day, the jury heard, played on Exhibit 1008, a lengthy discussion between Dr. Reed and Mr. Holmes in which they discussed the charged offenses in great detail. And this discussion between Mr. Holmes and Dr. Reed was the subject of paragraph 70 in motion D264A. And while the defense maintains that all of the statements and all of the statements specifically described in D264A are admissible, we're moving for a mistrial now after the jury has heard these particular statements because Mr. Holmes' detailed statements about the offense are among the most problematic and unconstitutional from the defense's perspective. We do anticipate that there will be some more discussion of the offenses between Dr. Reed and Mr. Holmes in future videos, but this is, from my recollection, the first time on Exhibit 1008, which is segment 6 of the videotape, that they really get into the details about what happened in the theater, and so that's why we're making this motion now, after the jury has actually heard that evidence being played in the courtroom. As just a few examples among many others, the jury has now heard Mr. Holmes state in his own words that he shot at people who tried to run away, that he did so because he can't, quote, can't have people running away. They've heard his detailed description of his difficulty reloading the AR-15. They've heard his affirmative response to Dr. Reed's statement that you wanted to kill people. We've heard his response to Dr. Reed's question whether if anyone in the theater had made a surrendering motion, would you have shot that person, as well as his statement that he was prepared to shoot a theater employee taking out the trash if necessary. The defense maintains, as we always have, that the introduction of these statements violates Mr. Holmes' Fifth Amendment privilege against self-incrimination, his Sixth Amendment right to counsel and a fair trial by an impartial jury, his Eighth Amendment right to a fair and reliable sentencing proceeding, and his 14th Amendment right to due process, as well as Colorado Constitution Article 2, Sections 16, 18, 20, 23, and 25. And we also maintain the introduction of these statements violates Colorado Rule of Evidence 401 and 403. Even assuming some of these statements are arguably probative of sanity, many of them are far more probative of guilt, and so their admission creates a substantial risk for unfair prejudice that outweighs their probative value. We understand, well, and let me also say that the statements violate these constitutional and evidentiary provisions not only because of the content of the statements themselves, which directly discuss the charged offenses, but also because of the form in which they were introduced through a videotape of Mr. Holmes himself, providing what we maintain and have always maintained as compelled testimony to the jury. And we understand and we respect that the court has previously ruled on these issues in various contexts throughout the course of pretrial litigation in this case. But now that these statements have actually been introduced in front of the jury, we felt the need to make a further record and request a mistrial. And lastly, I would add that because of the way the prosecution has chosen to present its case, these statements are being introduced affirmatively in the prosecution's case in chief, rather than in limited rebuttal to specific evidence of insanity that's been presented by the defense. In other words, they're being used by the prosecution on offense rather than in defense, and they're not being selectively introduced in response to specific evidence that we've actually introduced. And we understand that they ultimately have the burden of proof on insanity, but Dr. Reed's testimony is being sandwiched in between other evidence and testimony that bears on guilt, not sanity. And the context in which these statements are being presented makes any limiting instruction especially ineffective. The U.S. Supreme Court in Buchanan versus Kentucky and Kansas versus Cheever, which are cases that we've cited extensively in our pretrial motions on this issue, discuss evidence from a court-ordered psychiatric examination as admissible for a limited rebuttal purpose. And the Cheever Court specifically has acknowledged in a footnote, the Supreme Court pretty clearly stated in a footnote in Cheever that its holding suggests a constitutional ceiling on the scope of expert testimony that the prosecution may introduce in rebuttal in cases like this. And it didn't resolve conclusively what that ceiling is because that issue wasn't before the court. But it's our position, and this is a new argument in addition to the arguments that we've already made pre-trial on this issue.
Let me stop you there. This new argument is untimely. This new argument should have been made before Dr. Reed testified, not now. Why are you making it now? If you're going to, hold on, if you're going to make it now, make it an appeal. Or make it later in a post-conviction proceeding if there is a conviction. It doesn't make sense to make it now. What can I do now?
The motion is a motion for a mistrial, Your Honor, and we believe it's timely because
Ms. Nelson, as a lawyer, you can't wait until evidence is presented and then object and say, wait a minute, this is unfair. They're calling Dr. Reed an offense. They shouldn't be allowed to do that. Dr. Reed has been on the stand now for what, 5 days? You can't, if you were going to object to that, you should have objected before he took the stand. So as to that argument, it's untimely. And you can't raise it at this time. I can't do anything about it. Now, in terms of the other argument, if you want to continue to supplement the record, I'll let you do that. But this argument about the prosecution improperly calling Dr. Reed in their case in chief, that argument is untimely.
Perhaps I can clarify a bit for the court. I understand what the court is saying. I do. And we did not object to Dr. Reed's testimony in general when he took the stand. The reason that we're making this specific motion at this particular time is because it relates to the introduction as a whole of the statements about the offense, which were played for the jury yesterday.
Right, but you said that at least your last argument, Ms. Nelson, has to do with the fact that the prosecution put on this evidence in their case in chief. And what I'm telling you is, to the extent that you think there's anything unfair about that or anything improper about that, this argument is untimely. And I'm not going to hear it now. You can raise it later